Hereby, I open this academic ceremony in which Emma Jane Moulds will defend the academic thesis entitled The Patchwork in the Sky, an examination of how the 8 largest global aviation markets regulate trade, investment, and alliances between airlines. Dear candidate, may I invite you to present a summary of your study and the conclusions of your thesis. And I think you may have, yes, unmute. Yes, excellent.
Dear Prorector, dear members of the Corona and members of the audience, thank you for the opportunity to present the findings of my doctoral thesis entitled The Patchwork in the Sky. My research is an examination of how the 8 largest global aviation markets regulate trade, investment, and alliances between airlines. The economic regulatory framework for international airlines is unique when contrasted with other internationally traded goods and services. Trade and air transport explicitly sits outside the remit of the World Trade Organization and most major trade agreements. A passenger's flight options are instead the byproduct of a complex international regulatory framework. The Chicago Convention, the centerpiece of international air law, recognises airspace sovereignty as a fundamental right. However, the Convention is silent on matters pertaining to the economic regulation of airlines. In practice, airlines are instead regulated through a combination of domestic legislation and regulation and bilateral or multilateral treaties, commonly referred to as air service agreements. This diagram provides a very simple illustration of how this occurs in practice. For an American airline to provide transatlantic services, say between New York's JFK and London's Heathrow airports, it must firstly obtain an operating licence, a certificate of public convenience and necessity in the US, and it must secondly be authorised to provide services under the US-UK Air Transport Agreement. IATA has previously estimated that there are approximately 3,500 of these air service agreements governing air transport around the world. ASAs typically impose a number of restrictions on airlines. They may restrict the number of passengers an airline may transport and the frequency, capacity, and pricing of those services. They also require airlines to be substantially owned and effectively controlled by the designating state, its nationals, or a combination of both. Over the past 30 years, there's been international momentum to reform the regulatory framework for airlines so that they can fly between more countries and without so many of these restrictions. However, most jurisdictions have shown very little appetite to truly move away from the comfort of the bilateral trading system. The purpose of my research was to examine how the largest global aviation markets regulate airlines from 3 perspectives: trade and market access, investment, and airline alliances, and sought to consider prospective pathways for the future reform of the airline industry in the wake of COVID-19. The jurisdictions considered in this research included Brazil, China, the European Union, India, Indonesia, Japan, the United Kingdom, and the United States. Collectively, airlines licensed by these jurisdictions carried approximately 2/3 of the world's passengers between 2010 and 2019. Although there has been extensive English language research into these regulatory frameworks for the major markets, particularly the European Union and the US, literature to date has not considered these 8 jurisdictions as a cohort. The thesis is structured into 7 chapters. Chapters 1 and 2 provide an introduction to the research, the history of the regulatory framework, and multilateral approaches to liberalisation. Chapter 3 considers how each jurisdiction regulates market access through air service agreements. This chapter was prepared by examining nearly 100 air service agreements concluded between jurisdictions against 6 key elements. Those elements included designation and authorisation, traffic rights, frequency, capacity, tariffs, and dispute resolution. Chapters 4 and 5 consider how the jurisdictions regulate investment and alliances. These chapters were prepared by undertaking a legislative review of the key legal instruments, supplemented by examining legislative debates, government publications, and case law. Chapter 6 examines the impact of COVID-19 on the major international airlines licensed by the jurisdictions, and then explores 3 possible long-term regulatory reform options as the industry positions itself in a post-pandemic environment. Lastly, Chapter 7 summarises the findings of the research and identifies areas for future projects. I'll now turn to the key findings of my research. On trade and market access, at the outset, it was difficult to ascertain the exact status of air service agreements between jurisdictions. The Chicago Convention requires all contracting states to register a copy of any executed agreement with the ICAO Council. In 2005, the WTO noted that contracting states do not always comply with this obligation, and the ICAO Assembly has previously urged member states to register their agreements and arrangements with ICAO to enhance transparency. My research found that this is still a problem today. For the agreements examined as listed in Appendix A to my thesis, the research found that most agreements required airlines to satisfy traditional ownership and control criteria to be authorised or designated. All agreements provided at least first to fourth freedom rights. All agreements provided at least some form of dispute resolution process, and there were varying approaches to frequency, capacity, and tariffs. However, my research found that notwithstanding these restrictions, the temporary restrictions to mitigate the spread of COVID-19 have been the most significant barrier to market access during the pandemic. The environment in which international airlines were operating had never been more complex or more restrictive. With respect to investment, over time, the states have adopted very different approaches to foreign investment and control in licensing. At one end of the spectrum, the United States limits foreign investment in US licensed airlines to 25%, and at the other end of the spectrum, India and Brazil have significantly relaxed restrictions in recent years. While there are alternatives to the traditional ownership and control criteria, such as a principal place of business criterion, this has not gained significant traction in domestic legislation or air service agreements. On airline alliances, there is no overarching international framework determining how alliances should be regulated. They're instead subject to an airline's domestic competition or antitrust legislation. One alliance arrangement may be subject to review by multiple competition regulators, even though the agreement will relate to the same route. And it goes without saying, but regulators are not bound to reach the same decision as they're operating under their own domestic regulatory frameworks. When I first began this research in 2015, there was a strong focus within the industry around liberalisation. However, that focus changed very quickly in March 2020. Within weeks of the World Health Organization declaring COVID-19 to be a global pandemic, the airline industry was virtually grounded. Although many industries have not been immune from the impact of the virus and the measures undertaken by governments around the world to manage it, the impact on the airline industry was profound. By June 2020, international air passenger traffic was a mere 3.2% of traffic for the same month the year prior. Most of the large international airlines and jurisdictions experienced at least a 50% decline in revenue for passenger services in 2020, and airlines undertook drastic measures to reduce their operating and capital expenditure. Governments provided substantial financial assistance through recapitalisation, subsidised loans, payroll assistance, and fee waivers. State responses to date have tended to focus on immediate liquidity rather than longer-term reform. As a result of global events, this research pivoted kind of completely, rather than exploring 3 pathways in the context of liberalisation to now in the context of a post-pandemic environment. The 3 options considered in the research included a single agreement for the economic regulation of air transport, a regional trading block model, and incorporating traffic rights into GATS. We'll now quickly discuss those 3 options. A single agreement would be one of the most effective ways to improve the regulatory framework, not displace the Chicago Convention, but rather sit tangential to it. For completeness, such an agreement would need to canvass a broad range of issues, including traffic rights, designation and authorisation, capacity, frequency and tariffs, competition and dispute resolution. A single agreement could take one of two approaches. It could either recognise the commonality between the jurisdictions, such as first to fourth freedom rights and substantial ownership and control criteria, or it could be drafted to reflect a more aspirational position. However, there are many challenges to such a proposal. Firstly, the International Air Services Transit Agreement, which is commonly referred to as the Two Freedoms Agreement, and the International Air Transport Agreement, the Five Freedoms Agreement, they were originally intended to be the primary mechanisms to facilitate the exchange of traffic rights between contracting parties. The latter agreement has never gained global support, and attempts to formulate a new agreement on market access have also been unsuccessful at a global level. So although this is a preferable option, it's highly unlikely in the current environment. The second ambitious proposal is a regional trading bloc model. This model would involve two steps. Firstly, states would need to be a signatory to a regional air transport agreement to form a regional trading bloc. And secondly, those blocs would need to assume the role of liberalising international air transport on behalf of their member states. This could either be done between the trading blocs, which is shown as option 1 on the slide, or alternatively a broader single agreement, which is depicted as option 2. These blocs could take many forms and build upon the progress already made to date at a regional level. However, for the model to be successful, liberalisation within regions would need to be improved. Although there are already a plethora of agreements in place, and Chapter 2 outlines some of those, many agreements have not been completely implemented, or states have made reservations to some of the key provisions. The third option would be to incorporate traffic rights into the General Agreement on Trade in Services to bring air transport within the remit of WTO. Under GATS, a member state would be required to comply with the most favoured nation principle and ensure that it does not provide less favourable treatment to other WTO members than it provides any other country. GATS also requires member states to comply with certain transparency obligations. However, there's been little momentum to progress with this option to date. The Annex on Air Transport Services provides that at least once every 5 years, the Council for Trade and Services should review developments in the sector and how the annex could be further applied to air transport. The second session of the second review was held in October, or last held in October 2007, and no further reviews have subsequently been conducted. COVID-19 presents a really unique opportunity for states to reconsider the patchwork regulatory framework underlying international air transport. However, history suggests that crises do not always serve as a catalyst for reform. This research concludes that although the regulatory framework is opaque, archaic, and arguably no longer fit for purpose, the patchwork in the sky is likely to prevail for the foreseeable future. Thank you.
Thank you so much for your presentation. The opposition will be opened by Professor Schneider. Professor Schneider is Emeritus Professor of European Law at our university, and she is also the chair of the Assessment Committee.
Thank you very much, Rector. And dear candidate, I would like to start with congratulating you to your book and the patchwork in the sky and the very clear structure of the book with the very clear writing. And actually, it was a pleasure for me to start reading your book because it brought me back to the time when I was teaching actually with your supervisor, competition law, but especially also internal market law in the 90s. And when we had a lot of discussion on the open sky, etc. So it was really, and it brought me to some new insights because I haven't followed this subject so much recently. However, my question is concerning, it's a twofold, and it starts actually with what your last slide was, which is also more or less one of your last prepositions and conclusions, namely the COVID crisis and also the international situation does not change the situation, or it's not likely for change. Now, of course, your research was done before the energy crisis now started fully, but already in the awareness that something will come. and also in the awareness of environmental changes, which might have a change for serious changes for airlines. So one of my question is, would you expect that in the light of these developments, we can expect that a serious change will take place and the patchwork will have to be changed or regulatory measures have to be taken? And more concretely, I would like to know something on your issues concerning nationality and the licensing system, which you explained, where you also said we have developments in India, Brazil, and the European Union, but you don't expect much more in the coming future. Now, here I would like to have, what would you recommend for an improvement in this situation on the nationality licensing system? Thank you.
Thank you, highly esteemed opponent, for your kind words, and it was lovely to hear that it brought back some memories for you. I might start with your second question first in regards to nationality, and I might just begin by kind of stepping back to the origins of this research. Back in 2015, liberalisation was a key buzzword at the time. It was a key focus for the industry. And when I was framing up this research project, I considered these jurisdictions and thought, if we've got 8 jurisdictions and they account for 2/3 of the world's passengers that are carried on international air transport and for domestic, perhaps there's some sort of common thread between their regulatory frameworks that could serve as a guiding light for future reform and liberalisation. So that was, I guess, the context to the research originally. As I went through the research process, it became apparent that, I guess, this kind of common thread that I was looking for between these jurisdictions wasn't there in the way that I thought it was or would be. And that was particularly the case with the nationality rule. There are so different, there's different approaches in terms of not only whether they adopt a substantial ownership and control criterion, but also there's some jurisdictions that adopt a principal place of business criterion. But even on the jurisdictions that consider substantial ownership and control, the actual statutory limit is quite different between them, and the future thinking on some of those issues as they've been expressed in the ICAO Assembly are quite different. So I didn't find what I thought I would find when I researched these jurisdictions, and that's, I guess, why I don't have a kind of clear and concrete answer in regards to the solutions. The 3 options that I looked at, they're not necessarily new options. They have been discussed before, but they were, in this research, I looked at them from the perspective of the 8 jurisdictions, and then we're overlaying COVID on top. And considering all of those factors, I kind of reached the conclusion that there's probably unlikely to be any substantial progress to be made with any of those future options kind of going forward. The one thing that did strike me, though, when I was undertaking this research, and it was particularly with the market access and the analysis of air service agreements, was the lack of transparency, and that there were quite, Appendix A lists the agreements that I've analysed, but I did find that there were agreements that there appeared to be traffic reported for, but I just couldn't find them. And when I made various inquiries, I was unable to ultimately find some of those agreements that I assume are there. So in terms of a kind of concrete solution, I think definitely improvements in transparency and ensuring that states register their agreements with the ICAO Council is probably the guiding light in terms of the first steps going forward. In terms of your second question in regards to recent developments, it's very difficult. I don't doubt that there will be a lot of operational changes and challenges for airlines going forward. but we've seen that this regulatory framework has survived quite a number of significant events. And I guess the most common one that I can think of that's kind of comparable is maybe the 1970s oil crisis. IATA has previously done some analysis in the context of COVID, looking at these sorts of crises and the impact that it had on demand. And we've seen very significant situations like this. And there's been many.
If I might interrupt you there very shortly, I mean, the mid-1970 oil crisis, of course, can be to some extent comparable, but the situation on the air market is totally different. So the way how our air transport has developed, and we compare the 70s with today, I think it's close to impossible to compare it.
No, and that's a good point. I guess there's a range of other crises that have happened that have also been significant. Global financial crisis, for example, and we haven't seen that these big sorts of events have displaced the underlying regulatory framework that has held for quite some time, irrespective of the big changes that have happened within the world. So I guess in summary, I don't believe that the energy crisis will displace the underlying regulatory framework at a global level, but it will definitely have some significant impacts, operational impacts for airlines.
Thank you.
Thank you so much. Then the opposition will be continued by Professor Correa. Professor Correa is Professor of Public Law at the University of Paris 11. And he is also a member of the Assessment Committee. I would like to welcome him very much to Maastricht University today. You have the floor.
Thank you, dear Rector. Dear candidate, I want to join as well the previous congratulations that were made to you, because it's always an achievement to finish a PhD and on such a complex topic. And I have to confess that you must have been very courageous to start assessing this very global approach on the patchwork in the skies. Well, unfortunately, this is also part of our duty. We also have to go and ask you some questions. And knowing as well that it's sometimes a bit unfair, because you have to be concise, and every time we see what is missing. So I know this unfairness very well in advance, but I wanted to ask you as a first question, you indeed addressed the European Union air transport market, which is very specific if we compare it to the other markets in the world, but you focus mainly on the internal dimension among the 27 member states, without really digging into the external aviation relations of the EU. This was a bit striking in the first chapter, where you present the models of air services agreement as the Bermuda 1, Bermuda 2, and the open skies. And in recent years, the EU has developed a very specific kind of agreement where it's mixing liberalization and regulatory convergence. And that way is trying to push for, well, some of the EU model, I would say, regarding the rest of the world, most notably the neighbors, to be entirely honest, because this is where we can more or less impose what we want. But for instance, with the US and Canada, the EU has been trying to have them change their approach on ownership and control. If you take the 2007 and 2008 agreements concluded with the respective countries. You have the same in the field of competition law. If you take Morocco, Israel, the European Common Aviation Area, so the Balkan countries. So my question will be very simple. So why did you did not think that it was necessary to address more thoroughly those agreements? And as well, now I'm thinking about then the horizontal agreements when it comes to designation. So, well, is it because you thought they were too specific to the EU, that they were not demonstrating a more global trend, or is it because of another methodological decision that you took at some point when preparing your research? Thank you in advance for your reply.
Thank you for your question, highly esteemed opponent. It was really another methodological approach. In regards to the horizontal agreements, I do touch on it briefly in chapter 2, but I do acknowledge that it's not as expansive as it perhaps could be. In regards to Canada, it was a scoping exercise, and at some point difficult decisions had to be made. So I didn't assess the EU-Canadian agreement because I didn't look at Canada, and I've only looked at the agreements between the jurisdictions. So that's why that was excluded from the scope. What I will say in regards to the kind of EU and that horizontal dimension is that it is apparent from my research that for these major jurisdictions, their regional neighbours are very important trading partners for them. I think India is really the kind of only exception to that, but for most of the jurisdictions that I looked at, their regional neighbours were their most significant trading partners. So in terms of opportunities for future reform and focus, regional neighbours are definitely a kind of very important priority.
If I may, in my allowed time, just to follow up, because I think there is also philosophical or political difference, is that when you take a look at the traditional agreements, there is the approach on market access, traffic right. This you describe perfectly. But if you take the European approach, and also in the ASEAN, which you address as well, there is this idea that if you want to compete, you have to compete, well, in accordance with level playing field. You have to apply and abide by the same rules. So I'm just pointing you, in case you want to devote more thoughts to this question in the future, that liberalization, it's not only market access, well, according to this philosophy, it's as well the putting the conditions for the liberalization to go further. And if you have the same rules, the same philosophy and competition law, for instance, or on safety when it comes to ownership and control, because there is a strong link, at least historically, then you can go further in the field of liberalization. At least that was the idea of the 2011 US-EU joint proposal for the relaxation of ownership and control with a system of list. So, well, that was just a thought to explain why I was having this, but now I stopped talking. My colleagues know that the French defenses are super long, but I will not impose you this today.
And dear candidate, does that still give rise to any further thoughts on your side?
No, definitely something to keep in consideration for future work. Thank you.
Thank you. In that case, the opposition will be continued by Professor Truxell, who is Professor of Air and Space Law at Leiden University, and who is also a member of the Assessment Committee. And I also would like to welcome him very much to Maastricht University today. Great to have you.
Thanks very much, mevrouw de kandidaat, Ms. Candidate. The patchwork could be a quilt, and quilts can be awfully beautiful when pieced together. Sometimes the seams between the various patches may not line up, or may be too much of a gap. This is just to say that, while it has its limitations, I think we have to recognize that the patchwork in the sky, which you've also said in your presentation, has suited us so far, or it's been around for some time. And actually, global aviation has been, or was, quite booming until COVID knocked it down. And that patchwork has really also, given states the freedom, the autonomy to determine, to some extent, their degrees of aviation activity, their competitive advantage, identifying that, and whether to engage in sort of regulatory competition or regulatory cooperation, convergence. But I think that the COVID and the green transition, which you also mentioned a little, reveal that what is really needed is investment. Huge investment will be required, and I just wonder if you could choose, of course, some thoughts from your own research to support it. But if you could choose, would you argue that further relaxation or removal of foreign ownership limits by these 8 largest markets, or some of them, would that be the best and most expeditious way to ensure a more seamless patchwork? Or do you think that the sector's overall attractiveness to investors on the one hand, but also customers, may really hinge on, some future change to the market? I think what we've seen is that COVID the crisis has shown us that the whole system, the current system is rather vulnerable, with prepaid tickets issued in exchange for some future obligation to perform air services. So I wonder whether you think it's a structural, change to the structure, or change to the foreign ownership would be the best next step for your patchwork.
Thank you for your very interesting question, highly esteemed opponent. It's difficult, I think, is the simple answer, because in my mind, these issues sit together. And when I say these issues, I mean not only investment, but I think the market access issues, and then capacity, frequency, and tariffs are kind of part of a package rather than things that should be seen in isolation. Definitely there's there's a kind of a mixed, I think, position at the moment with COVID, but prior to the pandemic, there were definitely potentially advantages for airlines if foreign investment was relaxed, that they had access to alternative capital markets rather than just being limited to capital within their own state. Potential for opportunities to leverage off of knowledge and expertise from other airlines, and for some states, being able to attract that foreign capital into airlines of their own country can be advantageous. In regards to whether it would be the best or most expeditious way to improve the patchwork, I think that these issues need to be considered, all of these issues need to be considered together. I don't think that necessarily foreign investment on its own is the best way forward, because you can have foreign investment, but you can still have a very restrictive environment with regards to the traffic rights that are afforded under some of these agreements, because there are still some agreements which are very specific around point to point, and they name the specific cities within the agreement where airlines can fly. So I think in terms of going forward, these issues need to be considered collectively together. And as in terms of a most expeditious step, I guess refer to my previous answer. I think transparency around some of these agreements is probably the most important first step going forward.
So the air transport agreements are the focus, and the contents of those agreements, or
disclosure of those agreements and the arrangements in place. I think that has to be the first step, because you can't improve something that you can't see. And I think at the moment, the regulatory environment is very opaque, and it's also enormous. I mean, there's 3,500 agreements, so having that in a form that can be analysed, and I know that WASA is a form in which that can be done, but there's still holes in that framework. So,
are you, just very quickly, are you maybe inspired by, I mean, as my good colleague Professor Correa has said, by the EU's approach, because of course those agreements are very open, very public, very accessible. Does that give you some, I don't know, inspiration or hope as in future research and also future, a promise of I mean, you said earlier this thing about liberalization was a buzzword in 2015. I noted that down. And of course, there have been good examples of quite liberal steps taken. India, really big example. No one ever thought Air India would be privatized, not in this decade anyway. But that also marks the shift of going from the state, investment to the capital markets, or to private investment. I just wonder if you have a comment on that.
Yeah, sure. I don't have the statistics in front of me, but I was really surprised when I looked at the agreements by how old some of them were, and they were really entrenched in that kind of Bermuda 1-2 framework and the provisions. And so while there has been progress in certain pockets around the world, that's been definitely a kind of step forward on some of these issues, it does tend to be in certain regions and with certain key players that I wouldn't say is kind of a widespread approach, but it did strike me just how old some of these agreements were, and this really is a framework that is still cemented and rooted in history.
Thank you.
Thank you. The opposition will now be continued by Professor Schoenmakers. Professor Schoenmakers is Professor of European Law at the Open University and also Associate Professor of European Law at our university, and she's a member of the Assessment Committee.
Dear Mrs. Candidate, thank you very much for providing us with this very rich thesis containing such an interesting overview of the regulation of the aviation market. You have assessed so many things, the relevant legal sources, the documents, and you have described the regulatory system of different jurisdictions and the international rules that are applicable to this field. So your thesis was for sure not a patchwork, but almost a holistic approach, so to say. And the title of your thesis, The Patchwork in the Sky, reflects really your core concern, the proliferation of bilateral air service agreements that underpin trade in air transport services. And you estimate that this proliferation diminishes transparency and legal certainty, which in turn imposes economic regulatory barriers for airlines. So talking about this diminishing of legal certainty, you specifically criticize that one alliance arrangement may be subject to review by multiple competition regulators. And you even announced this today when you presented your PowerPoint presentation as one of your key findings. Even when an agreement relates to the same routes, it can be subject to review by multiple competition regulators. And that is true, but however, this is something that is very common in competition law. And I would argue that it is not really specific to the airline sector because there's no real ne bis and idem principle in competition law. So I was wondering, when you are talking about your key findings and your proposals for the future, you call them the longer term reform options. Do you think that these also can have effects in other sectors outside the airline sector, specifically when you talk about single agreements on the economic regulation of the airline sector? Do you really think that it can be expanded outside the airline sector, or do you think that your long-term reform options are still so specific that they are only or mostly suitable for the airline industry?
Thank you for your very interesting question, highly esteemed opponent. I think I might just start by referring to the multiple competition regulators point. That was not intended to be a criticism, but rather, I guess, a statement of fact that under different domestic regulatory regimes, it's possible for regulators to reach different conclusions. In regards to the long-term reform options, I take, I guess, I'm not sure if inspiration is the right word, but guidance from the US EU Air Transport Agreement. That agreement contains an annex on competition law, and it provides a process and procedures for information sharing between regulators. I see that as a mechanism that could be incorporated into either a single agreement or alternatively in a regional trading block model, either in agreements between different blocks or in a kind of broader model agreement kind of encompassing all of the regional blocks. So I think in terms of kind of it's always going to be something that is jurisdiction of regulators in their own jurisdictions. They have sovereignty to make decisions around competition issues, but in regards to where those issues would sit within a kind of broader framework, and the two options that, or three options I've discussed, but the two that I think are kind of most applicable, I would see that sitting in potentially an annexure like the US-EU air transport agreement.
Are you satisfied with the answer, Professor Schoenmakers?
If I just may, because I didn't hear the final part, just to say briefly again, whether you think it could be expanded, yes or no, to other sectors. I just didn't hear the final part.
Yes, so I don't see it as kind of independent of other issues. Ultimately, regulators, they consider a wide range of industries under their own frameworks. I would see this as an opportunity to encourage information sharing between jurisdictions, specifically in regards to air transport. Could it be applied in other areas potentially? But I haven't really thought that far ahead. I guess they're just some preliminary comments that I can provide.
Thank you.
Thank you. Now the opposition will be continued by Professor Coppens. Professor Coppens is Professor of International Economic Law at our university. I'm very happy to give him the floor.
Dear candidate, let me first start with joining my colleagues in congratulating you with this thesis. It's an extreme achievement, I would say. You've put a lot of clarity to a puzzle that was so complex. And as a trade lawyer, I found it striking to read with such clarity and coherence how this industry has achieved to stay apart and stay essentially out and not play by the liberalization rulebook to which many of the jurisdictions under investigation committed, at least for other sectors. So I found that very interesting. I also found it striking that in setting out the three options and exploring those options for the future, you come to the conclusion that also, at least in your view, in the near future, this industry will not play by the typical liberalization rulebook. What I would like to do in my question is to test three options that you put forward a bit further with you. And in so doing, I would like you to assume that once you've successfully defended this thesis, which I can tell you will be as of tomorrow morning for you, once you have done so, that you assume that you would become a negotiator for any of the jurisdictions under investigation. And I would like you that in that capacity that you address three questions. The first one is, which jurisdiction, if any, would you recommend that they push for adopting any of the three options set out in your thesis, and why? My second sub-question is, which jurisdictions, if any, would you recommend that they oppose adopting any of the three options set out in your thesis, and why? And then the final question would be that assume that you would be involved in ongoing regional trade agreement negotiations. Would you recommend any of the jurisdictions investigated in your thesis that they push for the liberalization of aircraft services in their prospective RTAs, regional trade agreements, or their reform thereof? And if so, which type of provisions would you like to see in those regional trade agreements? Thank you.
Thank you, highly esteemed opponent, for your very interesting and tricky question. I'm not sure, I guess I'm in a position or it's appropriate for me to comment on specific jurisdictions and what they should and shouldn't do. That's ultimately, I think, a decision for states. But what I will say is that the research, the economic research, suggests that liberalisation can deliver a wide range of benefits to states that include economic growth, employment, increases in passenger and traffic growth, such that jurisdictions, there are many benefits that can come from further liberalising their agreement. In terms of, I guess, the options that I've looked at, I think there's definitely merit in everyone moving in the same direction rather than pursuing different options. And for me, that's really a kind of choice. I think a regional trading block model is definitely the option that is probably most palatable, but the option that, or the two options that are probably the best are either a single agreement or to pursue a WTO option. The WTO option in GATS provides many benefits, particularly around transparency. There's also the dispute settlement system. But the ICAO Assembly has previously expressed a preference for these sorts of issues to not be pursued through WTO, but rather through the ICAO Council. And that position kind of lends itself towards a single agreement. There's obviously complexities with reaching agreement on such an agreement. In terms of regional trade agreements, air transport, it's explicitly carved out of most regional trade agreements. I think probably the TCA is the one exception, and that's a very recent development. In my view, and this is a very personal view, I think there's definitely more merit in excluding air transport from regional trade agreements and continuing to kind of pursue these issues through something within the context of ICAO, so as to not further fragment the regulatory framework. It's already very complex. We've already got lots of different agreements in place, including at a regional level. And if you then have separate regional trade agreements with air transport included in them, it makes a patchwork regulatory framework even more fragmented.
Thank you. Just going back to the sort of the first two sub questions. So just to put it simply, so which of the jurisdictions, based on the economic strength and weaknesses of its own airlines, do you believe would benefit most from adopting one of the three options that you have set out in your thesis, and which of the jurisdictions would have most to lose from such an approach and would benefit from the current patchwork?
It's a challenge, I think, for all of the jurisdictions, because they all have significant domestic markets. So compared to other states that don't have domestic markets, cabotage and the issues around that are particularly challenging and present some unique challenges for this particular cohort. Yeah, it's very difficult to say. I think it's ultimately, and I understand that you're seeking an answer, but I think it's ultimately, there are lots of considerations there that would need to be further investigated in greater detail than what I've done today at a high level, to be able to explicitly say which jurisdictions would be best suited to either option. That's an issue that would require very careful consideration by each jurisdiction with regards to their own airlines and their own industries.
Okay, thank you.
Thank you. Now I'm very happy to allow Professor Correa to ask the candidate a second question.
Thank you very much, dear Rector. Dear candidate, dear Mrs. Candidate, I have answered a second question, which is connected to, well, some of your previous answers. Actually, at some point you, well, and in your thesis and as well in your answers, you referred to the trading blocks, the regional trading block model. I have a question. Well, the first one that will be very simple, but when you address, for instance, Africa, do you know what is the main problem with the Yamoussoukro process in Africa? Then that explains why it has been delayed for so long in order to have a regional liberalization at the level of the African market. what would be for you, from the analysis that you carried out, the main problem of Africa regarding this? And it's just an example, because I could use another region, mainly in South America, if we took, for instance, the Mercosur.
I might address this with regards to the EU, if that is okay. When we look at the success of the European Union single aviation market, that has occurred over a phased implementation with a mandate that's much broader than just aviation, and there's institutional and governance structures that sit around that. And that's, I guess, a framework, and it's an important structure that's enabled that model to work very well. And it's a model, the single aviation market's a model that many other countries have sought to, or many other regions have sought to emulate, but that kind of key, the mandate coupled with those governance structures are very, very critical to the success.
Okay, so thank you very much, because you anticipated what was the second leg of this question, and I will be very, very short. Well, I would say, if you allow me to comment on this, that in Africa, the problems are twofold. The first one is the so-called problem of the spaghetti bowl, that you have countries participating to several sub-regional organization levels, such as the Western African and Economic Monetary Union. At the same time, they have the African Union objectives, and sometimes those are conflicting provisions. And the second one, which you pointed out, is the question of the institutions. So if you could answer to me very briefly on this, but do you think that as it stands right now, that the regional trading blocks approach that you support, or at least you foresee, could work, given the fact that at the global level, the regional organizations have very different kind of powers and address very different levels of liberalization. In Africa, it's fifth freedom rights. If you take the Caribbean, in the CARICOM, it's up to the seventh freedom right. But so those levels, how do you see it? Very briefly, to leave some time to my colleagues.
Thank you for your question. It's, I think, a very important element of the difficulty with the regional trading bloc model, is that although it's palatable from the sense that there are already these regional trading blocs in place, they are at different stages of progress, and therefore having a model where they all come together in some form is going to be difficult, because they're already at different levels.
Thank you.
Now the opposition will be continued by Professor Truxell.
Thank you, Director, Ms. Candidate. I'm coming back a little to my earlier question on patchwork, because patchwork offers an opportunity for states to compete. Actually, states could decide to harmonize their approach to competition law and so on, so as to make a level playing field on a global market. But in fact, there's also, well, I wonder what you think. Is there a push for, or an incentive for states not to align their approach, their policies, their laws with other states, so as to remain competitive on that global market? And because you're looking at these 8 large markets, largest markets, they have more or less, well, more equal bargaining power than others. So your focus is small enough on that group of 8 largest markets to be able to make maybe a conclusion on that. So my short question is, isn't the patchwork a good thing?
Thank you for your very interesting question, highly esteemed opponent. it's definitely a challenge. When I reflect on, I guess, where this started back in 2015, at that time there was the US white paper, which levelled concerns at the Gulf carriers around the subsidies that had been provided by their governments. We're now in a kind of completely different realm in COVID, in that we have a situation where we have a lot of airlines that have received significant financial support during the pandemic.
Yeah, so if I could just interrupt you there. So if then we would say that all these 8 markets have the same state aid rules, so they're all playing on a level playing field. That would eliminate the patchwork there, right? But there would still be patchwork in the bilateral agreements, multilateral agreements, foreign ownership, nationality, and so on. I guess my question, is that desirable, do you think?
Yeah, and in this sense, I would, I guess, revert back to the earlier discussion that we had around the transparency of the framework. We do have a framework where there are so many different countries that have very different positions, and the positions within these 8 jurisdictions, and I talked about kind of finding the common thread, are very, very different. I think there is value in continuing to try and find a way forward where there are some common threads on market access, potentially on foreign investment capacity, frequency and tariffs, so that we don't see an environment in which we have airlines that are not competing on a level playing field. There are many benefits that come from this for consumers, for states. I think there's definitely, definitely some further work to do, and it will be interesting to see. I know that the ICAO Assembly is meeting next week, and there's some various topics that are being discussed in regards to state subsidies and other topics like this. So it will be interesting to see.
So sorry to interrupt you, Ms. Candidate. So you think that the patchwork is a bad thing, but competition is a good thing?
Yes, I think that would summarise my position quite well. Thank you.
Very, very well. Thank you.
Thank you so much. Then we continue the opposition with Professor Schoenmakers.
Thank you, Mr. Prorector. My next question is a little bit more general in nature, because it concerns the differences between joint ventures and strategic alliances. Or at least what we see now is that if I read your work at least, then I always got a feeling that when you describe joint ventures or strategic alliances, that you more or less assume that they are going to be anti-competitive. However, if there's a joint venture or strategic alliance, it doesn't necessarily mean that there's a restrictive agreement or an abuse of a dominant position. But I often had a feeling that I tasted that was suddenly somewhere underlying your assumption. So I was wondering whether you could briefly elaborate on the extent to which a joint venture or strategic alliance could harm competition, and maybe also explain a bit what the differences or the disadvantages would be of such a strategic alliance compared to a regular merger agreement.
Sure. I might start with the second part of the question. We have strategic alliances as a result of this patchwork regulatory framework that we have. A strategic alliance is effectively a partnership between 2 international airlines, because one of those airlines, because of the ownership and control rulers are unable to operate in the jurisdiction of the other. If those rules were to be relaxed, one would expect to see that there would be more international mergers where two airlines would potentially come together. I think there's also the potential that we'd start to see a large airline potentially establish subsidiaries or more subsidiaries in other jurisdictions. And sorry, could you please repeat the first part of your question?
Yes, it was about that such a strategic alliance isn't necessarily a restrictive agreement. I would say more is needed before you could make such a claim. But if we would indeed obtain such a single agreement on trade and air transport services, would you then think that competition law concerns will suddenly disappear? So that is actually what I really want to know. Would such a single agreement make all the concerns go away or not?
I think it would ultimately depend on the contents of the single aviation agreement. If an agreement was to go back.
Hora asked.
You may briefly conclude your reply.
If an agreement was to include the traditional kind of commonality between the jurisdictions around substantial ownership and control, first to fourth freedom rights, we would still be in a world where strategic alliances are the predominant competition concern. Whereas if it was to move towards a more aspirational position, there's a whole different set of competition issues that would potentially arise from that. So it would ultimately depend on the content of the agreement.
MHA Moulds, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and the quality of your defense. And I request that you and your company await the results of our deliberations and our return online. Emma Jane Moulds. The degree committee here present online has assessed the quality of your thesis and the quality of your defense. In view of its positive verdict and taken into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor Van den Bosch is authorized to confer upon you this academic distinction in accordance with Dutch university custom. And I now invite your supervisor to take the floor.
Emma Moulds, do you promise to work in accordance with the principles of scientific integrity at all times, to be careful and honest, transparent, independent, and responsible?
Yes, I promise.
By the authority vested in us by law, and in conformity with the decision of the committee here present online, I hereby confer upon you, Emma Jane Moulds, the degree of doctor, and grant you all the rights attached by custom and law. As evidence of this, you will soon receive the degree certificate signed by the rector, the secretary, and the supervisors, affixed with the official seal of the university shown by the beadle. Emma, it is my privilege to pronounce the laudatio. Congratulations. Congratulations on a job finally done, but even more so on a job well done. It is my pleasure to be the first to address you with your new title. As from now, you are no longer just Emma Moulds or Miss Moulds, you are Dr. Emma Moulds. So, Dr. Moulds, this is the end of a long journey that started in 2015. Over the last 8 years, you combined work on your PhD thesis with demanding work as an Australian government official in different capacities, working for different departments. That in itself is commendable. And I've often asked myself, with a degree of envy, where you found the time and the energy to work on your PhD thesis. Over the years, we've exchanged hundreds of emails, and skimming through them, as I did this morning, is like traveling back in time. It reminded me of many of the highs and the inevitable lows in that journey that you have completed today. It reminded me of the moment that I realized that a number of aspects of your topic were way out of my zone of comfort, and that you needed another supervisor to make up for the glaring gaps in my knowledge of your thesis topic. I was very relieved, and I know you were too, when Brian accepted the invitation to become your co-supervisor. And allow me to take this opportunity to thank Brian for taking up this task and for all the advice he has given and the expertise he has shared over the past years in times which were challenging for him on a personal level. In the past 8 years, you've spent research time, I think it was in 2018, at the Institute of Air and Space Law of McGill University, of which Brian was the director. And in 2019, at the World Trade Institute of the University of Bern, where I'm Director of Studies. And if I'm not mistaken, it was during this day at the World Trade Institute that we met in person for the first and so far last time. But I may be wrong on this. I have this vague recollection that we may also have met once in Maastricht or Geneva, or perhaps even both. Anyway, I hope that we will have an opportunity to meet in person again before too long. I'm always looking for a good excuse to come to Australia, or perhaps it will be you coming to Europe. When you are in Europe, participating, as you did in the past, in international jumping competitions. We have recently not talked enough about this passion of yours. Before concluding, allow me to thank, also on behalf of Brian, the members of the assessment committee and the degree committee, Professor Schneiders, Correa Truxell, Schumacher, and Coppens, for reviewing and commenting on the thesis and for their opposition during this public defense. This is much appreciated by both Brian and me and you, Emma. Emma, it was a true pleasure to be your supervisor. I learned a lot from reading the drafts and the final version of your thesis. I wish you the very best in your professional future, be it working for one of the branches of the Australian government or doing something totally different. And let me conclude with this, because it is now, if I see well, almost, if not beyond, almost 1:30 in the morning in your part of Australia. Once again, congratulations.
Thank you so much. Dear Dr. Moulds, also on behalf of Maastricht University and our Faculty of Law, many congratulations on the degree that you have just acquired. That's not a small thing. The diploma testifies of the fact that this is the highest degree we have available at this institution. Summosque honoris, it says on the diploma in the Latin version. English version is also provided to you. Many congratulations also to your family and friends, and congratulations to your supervisors. I think it's a very special thing that you also defended here with us at Maastricht University. So thank you so much for that. And I thank the members of the committee also on behalf of our university and faculty for joining us in this online session. I say to the young doctor, please do celebrate, perhaps not still this evening, but then perhaps tomorrow. And I wish you and your family and friends well, lots of success. For you, lots of success. Many congratulations again on this degree. And with this, I close this